Hello and welcome to Government with Dr. Turner. Today we will outline the institutional rules and political influences that shape the Supreme Court and the decisions it makes. One of the most long-lasting impacts a president can have is in his or her appointment of federal judges, especially Supreme Court justices. A two-term president may nominate enough federal judges to fill 2/3 of total positions. Their impact on the Supreme Court can be even stronger depending on how many seats open up during their term of office. There are no constitutional requirements for being a federal judge. In general, presidents appoint judges with legal experience and of good character who have ideological and partisan views similar to their own. Often, before the president makes a formal nomination, senatorial courtesy is observed. Senatorial courtesy refers to the tradition of granting senators considerable power over federal judicial appointments in their home states. If the president and senators from a state belong to the same political party, presidents will consult the senators regarding nominations in order to speed up their confirmation in the Senate. Once the president formally nominates an individual, the nominee must be considered by the Senate Judiciary Committee and confirmed by a majority vote in the full Senate. In recent years, Supreme Court nominations have involved intense partisan struggles. Concerning Senate confirmation of presidential Supreme Court nominees, interest groups can heighten the conflict over a nomination. Typically, after the presidential nomination, interest groups opposing the nomination mobilize the media, public, and Senate against it. As we have mentioned before, the Supreme Court has both original and appellate jurisdiction. Its original jurisdiction include the following: cases between the United States and one of the 50 states, cases between two or more states, cases involving foreign ambassadors or other ministers, cases brought by one state against citizens of another state or against a foreign country. Only 2 to 3% of cases heard by the Supreme Court are original jurisdiction. The rest of the cases reach the Supreme Court through their appellate jurisdiction. In the U.S. court system, appeals courts examine questions of law, not questions of fact. The Supreme Court controls the number of cases it reviews with its appellate jurisdiction. The Supreme Court has rules that determine which cases it will or will not hear. Cases must meet criteria in 3 major categories. Courts may only review cases that are an actual controversy, not a hypothetical one. According to the Constitution, the federal courts can issue a decision only in response to actual legal cases. Parties to a case must have standing, the right of an individual or organization to initiate a court case, on the basis of their having a substantial stake in the outcome of the case. The case cannot be brought too late. For example, if one of the parties dies while the case is pending, the dispute might be moot. Aside from formal criteria, the Supreme Court is most likely to accept cases that involve conflicting decisions by the federal circuit courts, cases that present important questions of civil rights or civil liberties, and cases in which the federal government is the appellant. Ultimately, admission of cases can come down to the justice's personal interests. Most cases reach the Supreme Court by a writ of certiorari, a decision by at least 4 out of the 9 justices to review a decision of the lower court. This is from the Latin word for to make more certain. A writ of certiorari is an order to deliver the records of a particular case to be reviewed for legal errors. Annually, about 1% of all cases seeking Supreme Court review will be heard by the court. Accepting a case is only the beginning of a lengthy and complex process. After the court accepts the case, attorneys on both sides prepare the briefs, written documents in which attorneys explain using case precedents why the court should find in favor of their client. A person, agency, or interest group not directly a party to the case but with an interest in its outcome may file an amicus curiae brief. Amicus curiae briefs are significant because they may influence whether the Supreme Court decides to hear a case. Amicus curiae is Latin for friend of the court. Attorneys for both sides appear before the Supreme Court to present their positions and answer questions posed by the justices. Following the oral arguments, the justices discuss the case in secrecy to reach a decision on the basis of a majority. After a decision has been reached, one of the members of the majority is assigned to write the opinion, which is the written explanation of the Supreme Court's decisions in a particular case. The Supreme Court explains its decisions in terms of law and precedent. Although the media and public pay most attention to the Supreme Court's decision, the opinion of the Supreme Court in a case is the most important element of the court's decision. Opinions set the precedent for future cases. With regard to the lower courts, the Supreme Court's primary responsibility is establishing legal precedents that will guide their decisions. A written Supreme Court opinion that describes what the majority of justices decided is a majority opinion. Once a majority opinion is drafted, it is circulated to the other justices. A concurring opinion is a separate view written by a justice who votes with the majority but disagrees with its reasoning. Majority members who wish to emphasize a rationale may draft a regular concurrence. In other instances, justices may draft a special concurrence when they agree with the majority but disagree with the rationale presented by the majority opinion. Justices who disagree with the majority decision may choose to publicize the character of the disagreement in the form of a dissenting opinion. Dissenting opinions can be significant because dissents are signs that the court is in disagreement on an issue and could change its ruling. Justices may make a decision based on a number of factors. The liberal or conservative attitudes of the justices play an important role in their decisions. But political ideology is not as important as the justices' perspective on how to interpret the Constitution. The two main approaches to interpreting the Constitution are judicial interpretivism and strict constructionism. Constructionism holds that if the meaning of the Constitution is to be changed, it must be done by amendment. Otherwise, the Constitution should be interpreted in light of the founders' original intent. Interpretivism holds that the Constitution is a living document and justices should interpret it in light of social changes. Let's review. In the U.S. court system, appeals courts examine questions of law, not questions of fact. Senatorial courtesy refers to the tradition of granting senators considerable power over federal judicial appointments in their home states. The two main approaches to interpreting the Constitution are judicial interpretivism and strict constructionism. The opinion of the Supreme Court in a case is the most important element of the court's decision. Concerning Senate confirmation of presidential Supreme Court nominees, interest groups can heighten the conflict over a nomination.